All right, now we return and we take up this issue of employment at will. And then this is something that you probably have heard about. You've heard those words before, the employment at will doctrine. And when I say employment at will doctrine, I talk about that fundamental idea that an employer can do anything it wants as long as it's not based on wrongful grounds. Now, this is the foundational principle of United States employment law, that unless the parties say otherwise, the relationship between the employer and the employee is based on the notion of employment at will. And what employment at will says is that either party is free to terminate the employment relationship without notice or without cause. And so oftentimes when you hear about employment at will, you hear about it from the perspective of the employer can fire you for any reason that it wants. The employer can demote you for whatever reason it wants. And that's true in large part. However, it is equally true that the employee can leave the job at any point. We often talk about giving 2 weeks notice for your job, but that 2 weeks notice is a courtesy. Calling them up the day that you don't come in is a courtesy. That employment at will says that if I don't feel like going to work that day or anymore, I can simply ghost the employer. Go take another job. That's the idea of employment at will. Now, employment at will is rooted in the idea of freedom of contract. And we mentioned freedom of contract in our introduction. And this is a concept that's going to follow us through this course. And what it says is that the job of the state, I mean just the government, the state should respect the choices of parties who enter into a contract. And so employment at will is based on the idea that the parties are free to contract to whatever they want to contract to. And if they choose not to contract to a specific term of employment, then the parties are free to leave. The parties are free to terminate that relationship at any time. Now, employment at will is the default rule in virtually every state in the country, that employees are presumed to be at-will employees. Only Montana has a rule that says an employer must have cause in order to terminate a employee. So in the United States, only the Montana has this for-cause standard. In every other state, the basic rule is employment at will. When we talk about things like discrimination, discrimination is going to be an exception to the fundamental principle of employment at will. The rules, the prohibition on discrimination is an exception to that fundamental principle of employment at will. Now, the interesting thing about employment at will is that here it is, the fundamental foundational principle for employment law in the United States, and no one is quite sure where this concept came from. And we first saw it in a court case, in a case called Payne versus the Western and Atlantic Railroad Company from the 1880s out of Tennessee. And in this case, the facts of the case are this, that Mr. Payne was a shop owner working for a company in a company town run by the railroad. And if you're familiar with history, you know that in this period, the 1880s, wealth was concentrated in the railroads. So railroads had a lot of power. Mr. Payne was a shopkeeper that somehow crossed the railroad company. And so the railroad company told its employees, you cannot do business with Mr. Payne or you're going to get fired. You'll be fired. And so Payne's business, of course, drops off tremendously. And he winds up suing the railroad company. The court eventually sides with a railroad company, but they do so in a way that says, look, the railroad company could have fired these people for any reason it wanted, good reason, bad reason, or no reason at all. And therefore, because of that power, then they are free to tell their employees not to do business with Payne, because they could fire you for any reason. And so this was the first time we saw the employment at will doctrine actually referenced in a case, and it quickly became picked up by other cases, by other courts, and soon it spread throughout the United States. And it simply says an employer can make any decision it wants for a good reason or for a bad reason or no reason at all. That's employment at will. Now, the employer's ability to terminate the employment relationship, however, is still limited by statute. Remember I said an employer can do anything it wants as long as it's not based on wrongful grounds. And if a statute prohibits an action, then that ground becomes illegal. So, for instance, an employer cannot violate anti-discrimination laws. Why? Because to fire someone because of race, color, sex, national origin, religion, age, or disability, that takes it out of employment at will. I can fire this person because I don't like their attitude. I cannot fire them because I don't like their ethnicity. So an employer cannot violate anti-discrimination laws. An employer can't terminate an employee in retaliation for exercising statutory rights. We'll talk about retaliation in a future lecture, but in essence what it says is if someone exercises their statutory rights, say making a complaint to the Equal Employment Opportunity Commission, then you cannot take an action against them for doing what they had a right to do. Tort law or public policy can also limit an employer's ability to terminate relationships or to take any adverse employment action. Again, there are some things that may not be illegal, but we say they are bad for society as a whole. Say your employer says, look, you're going to testify in a lawsuit, and here's what we want you to say. Tells you to lie on the stand. You get on the stand, you tell the truth, and so your employer fires you. Well, that may not have been illegal to tell you what to say on the stand, but we know it's wrongful, and therefore that limits employment at will. So most of what we'll be discussing in here has to do with limitations on employment at will. Now, this employment at will is a doctrine that is prevalent in the United States, but pretty much only in the United States. In most other countries, there are laws that protect employees from unfair dismissal. What that means is there are laws that say you cannot take an adverse employment action unless to do so is you got a reason for it. They're for cause. That's the standard in most of the rest of the world. So the United States is really gone its own way in terms of the employment at will doctrine. Sometimes countries have special courts, special employment law courts that address these types of claims, whether the adverse employment action was for cause or not. You have to have a reason for what it is that you do. Now, some would argue that in fact, however, that in actual use, the United States system doesn't differ that much from the rest of the world, because the fact is, once an employer hires someone, once they go through the trouble of going through the hiring process, they want to keep that employee. Employers rarely fire employees for no reason at all. or for bad reasons. That if you look at the number of relationships that are terminated in the United States versus those in Europe, the numbers are not that much different. And so some would say that we don't need a for-cause law because in essence one is already existing, that employers are not going to go fire people without a good reason for doing so.